All right, welcome back everyone to Pardalis and Nohavicka's deposition training. This is the sixth installment. So by now you have a pretty good idea of the format and how we run this. I know we have some new people on here. That's okay because you're definitely going to be able to hop right in and you'll see exactly where we are, and you're going to definitely benefit from this. So let's get right in. I know I repeat things a lot with respect to the approach to opening up the deposition and how to handle certain objections and everything. It's okay. That is planned. We're going to be going over them for a long time, even after this deposition seminar is finished. It's part of the practice, and you're going to be able to understand as you go through your careers what the basis of these objections are, why they're important, why it's important to object, and why it's important to not object. But at least you'll understand that you have the option, and you'll understand that you have to perform a metrics analysis on each time you decide, or each time you're deciding that you're going to object or not. We're going to have a little conversation with one of our attorneys at some point during the next hour. They actually conducted a deposition we were preparing for, and I think it'll be pretty interesting to hear what the comments are to see if we did a good job here in preparing you all for your deposition. And I look forward to all of you trying out your first depositions and giving me some feedback so I can have a better show. That's what it's all about, right? I handed out, I hope everybody has it, our objection sheet. I hope that is used by all of you for purposes of deposition training, preparing and understanding what the depositions are about. And the whole Marvel Axe thing is a mnemonic that I have used. You can use your own. And you see, we talked about Marvel Axe objections in the past, and I had specific objections to each one. I added a few on there. Okay, but anyway, just divert your attention away from that for just one moment, and let's go to the deposition itself and how we handle getting into the gate and coming out of the gate. Okay, so as usual, by now you all know that we introduce ourselves to the court reporter, and we give them our card and we tell them who we represent, and hopefully we have a copy of the caption so that they can put it into their transcript that they're putting together. And everybody's seated, you're ready to go, the witness is across from you. You direct the court reporter to please swear the witness in, get the first two on, and give me the green light when it's okay for me to begin. All right, I know we've been through this, let's just do it real quick, okay? And it starts out nice and easy, and I don't want you to use what I say. You have to find your own voice, okay? And what's going to work for you, and you find that out by trial and error, okay? You're gonna watch other people do it. You can say, wow, I like how they did that, but I don't like what they did there. Take what you find useful, disregard what you find to be not useful, and then add in what you think will be helpful to you. But the more relaxed you are, the more yourself you are, the better time of it you're going to have, because people will detect right away if you're being phony with them or not. So here we go. The court reporter is all set. He or she is waiting there and on their little machine there, and they're ready to go. And they give you the nod. You say, good morning, Israel Klein. My name is Joseph Nohavicka. I represent the plaintiff in this case. I'm going to be asking you some questions about an incident that occurred in 2018. Now, if I ask you a question that you don't understand, please let me know, and I'll try to rephrase it into a form that you do understand. Is that agreeable to you? And they will say yes. And you say, really an important rule that we both have to follow is that you just allow me to complete my question in full before you give a response. And the reason for that is the court reporter is taking down everything that we say. And this document is going to be very important because it's going to be used in court at some point. And we want to have a transcript that has a complete question, which is mine, followed by a complete answer, which is yours. And when people start talking over each other during the deposition, two things happen. Number one, the court reporter is going to have a nervous breakdown. And number two, you can have a transcript that is garbled and is not going to mean anything to you. You understand this? Yes, it is. Please just let me know if you need a break, and we'll be happy to provide that opportunity for you. Do you understand these instructions? All right, so let me just stop right there. So that's basically it, and you're developing your rapport. There should be no objections by opposing counsel. They may be rolling their eyes or reading the paper, whatever it is. Just do this as naturally as you can and get it done, okay? So now you're ready to begin your questions where you're getting actual information. You already have the name and address of everything. So there's a couple of things that you want to be careful about when you're coming out of the gate. You don't want to set a bad tone with the other side by letting them get away with things right at the beginning. You have to set the tone. And if I could just refer you back to the objections sheet that I handed out, you'll see at the bottom, I believe I have objections to counsel's behavior. And if you see that, it has a list of things of what they're not permitted to do. We'll go over them, each of them individually, and give examples of it. But you don't want to set a bad tone where they're talking and where they're having discussions or with their client witness, where they're pointing to portions of. I mean, some attorneys are trying to be helpful and they direct their attention to the page and the paragraph or sentence where you're trying to refer them to, and I suppose that's okay. But you want them to have as little involvement as possible during the course of the deposition. You really want them to be sitting there like a potted plant, just making sure that all your questions are legal and their client is not being abused. Okay. So you're going through your pedigree, and you're getting their date of birth, and now all of a sudden you hit something like their employment history. Okay. And let's pick a type of case where employment history may not be that important, like it's a partnership dispute, for example. And it may you may have a reason, when you're developing your plan, you may have a reason to require that information, to get that information. But let's just assume it's just a straight partnership dispute, and you really don't need to know where they went to high school. Okay. But you ask them. So I'm going to talk to you now about your education, and can you please tell me, where you went to high school? And counsel objects, and they say, objection, that's irrelevant. Why are you talking about his education and all that? First of all, they broke a rule by engaging in speaking objections. You're not allowed to do that. The most that opposing counsel can do is object to form. They believe it's irrelevant. Okay, that's fine. Objection to form. You can answer over my objection. But in this case, the attorney says, no, I'm not letting him answer that. You don't need that information. This is, this deposition is going to go on all day. I'm not allowing it. What do you do? We talked about the different remedies that we had. We talked about having the judge's phone number on hand and giving them a phone call saying, okay, something, we're going to go to the judge with this. If you're going to direct them to not answer, we're going to go to the judge. Okay. That is something that you could do, but you have to lay a foundation before you do anything. Even if you decide to do nothing, you still have to lay a foundation. So we're talking about high school, and the question is, where did you go to high school? The attorney says, something, I'm not letting him answer that question. At that point, you don't even look at the attorney who's speaking. You should be, your attention should be focused on the witness. And you say to the witness, where did you go to high school? And they look at their attorney, and the attorney says, I'm directing him to not answer the question. You remain focused on the witness, say, are you refusing to answer? That is a really important part of this whole thing. You have to get the witness to say, I'm refusing to answer that. I'm not answering the question. got to listen to my lawyer, whatever it is, all right? Then you turn your attention over to the objecting attorney who has improperly directed his client to not answer the question, which he has absolutely no authority to do in this situation. And you say, are you directing your client to not answer the question? And if he says yes, at that point, you say what I would do is I would go back again and say, to the witness, are you refusing to answer the question? And they say, yes, I already said that 2 times. You say, fine, mark the question for a ruling. Okay, now you've done your job. All right, right then and there. What you decide next, it doesn't matter. So far, you're really good at this point, okay? Because you can at this point say, okay, look, if we can't agree, and this is how the deposition is going to go, I'm going to stop right now. We're going to call the court, and we're going to get a ruling on this. You can do that. I would not do that. It's way too early, number one. And then you have to perform your analysis. What are the metrics? What do you win? What do you lose by allowing them not to answer the question? Well, you lose nothing because you have reserved your right by what I just showed you what to do. You just reserved your right to make a motion to compel the answer to that question at some later date. Do you really need that information at this point? The answer is no, you don't need that information right now. You don't have to stop anything. It's been marked for a ruling and you can proceed through. And what I do in that situation, if I really don't need it, I have it marked for a ruling. At the end of the deposition or at the middle of the deposition, because I made a note in my pad that they didn't answer this question, I ask again, and I'll try a couple of times. Who knows? Maybe they're hiding something. If it's a plaintiff on a personal injury case, the high school question may be very important. They may have, they're complaining that they got rear-ended. It was a low impact case and they have a torn rotator cuff. Something, then you find out that in high school they played varsity football and they did not play in college football because they ripped out their rotator. I mean, it's possible, it's happened. That information could be very, very important at some point, And when I say, mark it for a ruling, I usually add something like, and I reserve my right to reopen the deposition in the event that we get a positive ruling on whether that question was appropriate. And, that gets them thinking so that, when you give them a chance again, you give them an honorable way out of this ridiculous position that they have taken. They may reconsider and allow you and allow the questioning to go forward. So you're in a good situation right there. But I'm not going to stop the deposition at that point, depending on who I represent. If you represent the plaintiff, you're worried about you're considering costs, you're considering time. You want the case to move along to get to your pot of gold if you're the plaintiff. Delay is not going to help you. Usually. Do I really need the information as part of your metric analysis? Do I need this? Do I really need this in this type of case? And is weighing what I'm going to get from this question? How does the delay in this case? How does that affect everything? Is it really worth your while? So back to what I said in the beginning about setting the tone. If you go through that litany and you go through that little procedure of questioning and laying your foundation, you have given your opposing counsel knowledge that you know what you're doing and that you're going to make a motion most likely, and that they have exposed their client to having to appear again and possibly expose themselves and their firm to sanctions for not allowing, depending on whether you're in federal court or in state court. In federal court, that would be sanctionable. You would get your sanctions if just by virtue of the fact that you made a motion and you got certain relief, you're entitled to attorney's fees for everything you had to do for that, including the motion and all the letters that you wrote and the appearance at the motion, whether that's remotely or in person, and having to go to another deposition because of this ridiculously improper behavior. Okay. And that's how you move along. That's how you decide exactly what you need. That's why it's so important that we talked about having a plan about what it is that you want to get at the deposition. See, there are a lot of tough attorneys out there who believe that trial is combat. Because it makes it sound very, I guess, macho and but it's been my experience that litigation is not combat at all. Not in the sense of hand-to-hand combat or wars or anything like that. And I mean, you want to call it chess combat, then yes, I would agree. Sometimes it's like that. But really, what we do is more like what chefs do. All right. And I'm not trying to be funny, but we're trying to prepare something for an audience to test and to taste and to see if it's palatable, if they can swallow this story that you're selling on behalf of your client. And the deposition would be then going to the supermarket to pick up your ingredients so you can prepare this banquet that's hopefully going to be better than your opposing counsel's. So stop with the fighting, stop with the war metaphors, and let's cook some carrots. Okay, so that's keeping in line with that, so we don't make this into a battle, because I mean, look, arguments happen, and sometimes, look, there have been situations where attorneys have actually jumped over the table at each other because they were so furious. That's sanctionable. Probably go to jail. I think there was a Cup of Joe about an attorney going to jail for that. So, you don't want it to get like that. It's like I said. Let's prepare. Let's use our brains and our skills and prepare a great case. And while we're at the deposition, we're learning how to shop and learning how to get the best ingredients. And using that metaphor, the other attorney is trying to prevent you from getting the ingredients that you need for your case. And you just have to shoo them out of the way politely and by knowing the rules, which is what we're doing right now. So let's go now to the Marvel Act's objections to form. I can't impress upon you enough the importance of actually memorizing these objections so that you're able to protect your record. And so I'm just going to go over it again. As you can see, the M in the Marvel Act is for when a question is multiple, and that is, and Stacy showed us last week, when we dissected the frog of the other deposition, how the attorney would ask 2 and 3 questions within one question, which is ridiculous, and it's improper form. But again, you're going to, if the other attorney is asking multiple questions, you're going to say objections to form, and to your client, you can answer over my objection. And that's it. That's it. You don't say objection multiple unless opposing counsel says, what is the basis of your objection? And then you can say multiple at that point. One of the M's that I added to the M in Marvel Acts is mischaracterization of prior testimony. So the questioning attorney says to your client, you testified that you went through the green light. I'm sorry. You're prior. And when I asked you a few minutes ago about whether you went through the red light, you said yes. And the witness never said that. That is a mischaracterization. So that's why, again, it's so important to listen to the questions all the time. It's very, sometimes the depositions, they can get very rote, they can get boring sometimes, especially if the other attorney has no plan and they're not getting anywhere. And you could end up losing your attention span, which is a terrible thing. You really have to pay attention, because the mischaracterized testimony, if not objected to, can be used against your client. So that would be a really bad thing, whether it's on a motion or whether it's at trial, okay? Because these transcripts can be used on both the motions and the trial. So there you go. The M, you have the objection as to form, multiple, objection, mischaracterization of prior testimony, and there is your M objection, okay? Next, you go to the A in the Marvel Acts, and we have this objection assumes a fact not in evidence. And that's where an assumption is built into the question that has come out of nowhere with respect to the universe of that deposition that you're in right now. So, the question says, so you were a passenger in the car, and did you speak to them, while they were going through the intersection? And there's been no testimony that they were a passenger, and there's been no testimony that they were speaking. So there's an assumption that's built into the question. So you have to pay attention, and you object to the form. Now, I mean, that sounds like it could be a terrible thing. Do you tell your client, do you tell your witness client to not answer the question? Absolutely not. Absolutely not. But you object to the form. And if you're asked for the basis, then you tell them, counsel, it assumes the fact that it's not in evidence. You have built in an assumption. Now, you see, I added a little bit there. That's not really arguing it rather than amplifying, which is appropriate. You can do that. You're just not allowed to argue and engage in what they call colloquy for, 2 or 3 paragraphs or 2 or 3 pages in the transcript. So amplifying is okay, colloquy is not okay. So now we get to the R in Marvel Act for the repetitive. And that's, you probably heard it on TV, if not in court, as the asked and answered objection, which a court will understand. The record will reflect that you objected because it is repetitive. But even though you didn't say repetitive, I say repetitive because repetitive is actually in the statute. So I prefer to use repetitive. This way there's no mistake. And I think the asked and answered because it's used so much on TV that it's gone bad. So I prefer repetitive. It's going to be up to you. And plus the R fits in there nicely for my Marvel X mnemonic. So then we come to V for vague. And vague, again, is a close cousin of confusing. Vague is also a close cousin of ambiguous. So you're going to object to the form, and if they ask you for the basis, you're going to say vague. I don't think you get in trouble if instead of vague you used ambiguous, and I don't think you'd waive the objection if you said it was confusing. But know the difference between each of them. We're going to go into that a little bit, okay, as we go through each of the letters. So the next one we hit is irrelevant, and you hear, especially the attorneys, they hear over and over that relevance is not an objection that you can use during a deposition, and relevance is very rarely sustained at trial. But you know what? It's considered to be a form objection. Object to the form, answer over the objection. What's the basis? High school has nothing to do with this case. Okay, fine. Mark it for a ruling, or, again, do the metrics on it. But you should object if you believe that it's irrelevant. If you believe the question is irrelevant, you can object to it. And if it's a federal court case, you just remember Federal Rule of Civil Procedure 26, which talks about discovery being limited by proportionality and relevance to the prosecution or the defense of the case. So you have some doctrinal support in making that objection, but don't tell them to not answer the question unless the question is really palpably improper. And we'll get into that. That's like a trick phrase too, that we'll talk about in a little bit. Getting to the L in the Marvel Acts, we have a couple. We have leading, and you all know what that is, right? Leading as opposed to the who, what, when, where, how questions, which are open-ended, and how all of our attorneys at PN conduct their depositions using those, starting off with those words. Leading is not using those and saying, so you went through the red light in the intersection, right? that is a leading question, okay? So, and as opposed to what color was the light at the intersection at the time you went through, The next one that we haven't spoken about before is, in the L in the Marvel Acts, is the lax foundation. And the lax foundation could also be considered a cousin of the assumes fact not in evidence, because it lacks foundation if the question is talking about something that has never been mentioned before or has not been established. Um, for example, if the witness does not have personal knowledge of something and the question assumes that they have personal knowledge. So that would be, if you say objection to form, and they say, what's the basis? You say it lacks foundation. Could you give us some testimony as to how it is you believe that this witness could even answer that? Again, that is not colloquy, that's amplifying so that the question, that the objection is understood by your opposing counsel. And then the third one's a little confusing. The question lacks question. Unless you were here last time as we dissected that frog of a deposition that we were working on, there were actually, it has QA for question, answer, and the attorney had a Q, and the next thing was just this long statement, and it didn't have a question. There was no question mark at the end of it because it would not have belonged. There was just no question. And you could, if the attorney makes a statement and with no question, you say objection to form, and they'll say, what's the basis? You say, look, you didn't ask a question, so at least it gives them a heads up, and maybe they didn't realize it, who knows, but that's how you make that objection. And then we come to the A for, again, this is the second A in Model Acts, and we have argumentative and we have ambiguous. Argumentative can sometimes mean that the question is just being combative, like you came here, you came to this deposition knowing full well you weren't going to cooperate, right? Yeah, that's a question, sure, it's a question, and it's a leading question, but clearly it's not asking for information that you're going to need for, or that the attorney's going to need for the defense or the prosecution of his case, and clearly he was there just to get them upset, so that would be an argumentative objection. Probably irrelevant too, but I would rather say argumentative at this point, since irrelevant is the last objection. It's the objection of last resort. So, and then the other A in this portion of the Model Acts is ambiguous, again, which comes close to the confusing and to the vague, where any answer to it could be reshaped to make your client sound like they're saying something that's against their interest. So, and I'll give an example of that. So back to the C and the Marvel Act, which is for confusing, and which we talked about, and calls for a conclusion, such as, is it illegal to go through a red light in Mount Vernon? It calls for a legal conclusion that you wouldn't even ask a lawyer that question. It's probably argumentative too, but anyway, it calls for a conclusion. And then one we never talked about is calls for a narrative. So the question would be something to the effect of, tell us about your college career. It's really, that could be a novel, So you object to form, you can answer over the objection. No, but at least your objection is preserved. Okay, and you were able to identify exactly what it is. All right. So those are the form objections. Okay, and so let me just break it down a little bit into let's say you're defending, you're doing the deposition of a defendant driver. You're defending the defendant driver, and some of these questions come up, and I know some of you have asked me about them specifically. Like one is immigration status, and this is how I handle them. All right, so they ask about immigration status. So objection, the question is palpably improper, or it's not reasonably designed to lead to admissible evidence, which is still the standard in state court under Rule 221 of the Uniform Rules of Trial Courts. Are you trying to embarrass my client, or are you trying to embarrass the witness? So I'm directing the client to not answer that question. And you know what? Mark it for a ruling. All right, that is something that I would do. I can't say you should do that, to air that it's going to be something that's personal. It's going to matter on what kind of case it is, as to whether you get that. And, if it presents a situation where your client would be exposed to immigration consequences, I would require a court order directing the release of that particular information. So that's how I would handle that. And I know we can have some discourse on that, but that's how I have handled it in the past, and I will most likely continue to do it that way. It's going to depend on the situation. Okay. Here's one on the Social Security number. And again, this is one that we go to the metrics on, and it depends on what kind of case. Do I really need the answer to this question, or do I have this information somewhere else? If it's an employment case, I guarantee you it's somewhere in that information, the Social Security number is somewhere in the record, or it can be demanded under using devices where that information would be protected. But let's just say it's a cold record, and I don't even know what the record is, and I was just retained to handle the deposition, and I'm going to say objection. The question is probably improper. It's not reasonably designed to lead to admissible evidence, again, which is still the standard under Rule 221 of the Uniform Rules. The information is personal, and I'm directing my client to not answer it. And counsel, you should know this, because even if you're going to file a motion, you would have to redact this on the motion. So you know what, mark it for a ruling. All right. And that's how I would handle the Social Security. Again, we could have debate on that, and it's going to be a choice that's personal to you, and it's going to depend on the type of case. But that's how I have handled it, and I'm still here today. So that could just be by luck, though. So, now we're talking about, like, for example, we did a lot of taxi defense litigation, and they would say, has your driver's license or hack license, which is the taxi license, ever been suspended? And I would object. Again, that question is palpably improper. It's requesting information respecting other bad acts, right? Other bad acts, OBA, you remember that? Other bad acts are usually not admissible in negligence cases. There are exceptions. Certainly in criminal court, we have, our Molyneux rulings, but that's a separate thing, and we'll talk about that during our criminal defense seminar, which I'm really looking forward to do with everyone. But anyway, back to our objection. It's not reasonably designed to lead to admissible evidence. Again, in federal court, the question is not proportional, and it's irrelevant to your defense or the prosecution of your case. Bouncing back and forth from federal to state. And again, are you trying to embarrass the witness? What do you hope to gain from that? Direct them to not answer. Mark it. You know what? Mark it for a ruling. Mark it for my ruling. So because you can. You can mark it for a ruling for purposes of a protective order, just as easily as you can mark something for a ruling for purposes of compelling an answer. So just keep that in mind. How about the question, have you ever been sued before? I know we talked about that. Have you ever been sued before? To get that information, you can ask better questions for certain, such as, have you ever been deposed before? Have you ever given testimony before? Have you ever signed any statements that were submitted to any court or tribunal or arbitration tribunal, whatever it is? And you'll get the answer to that question. But the raw question of, have you ever been sued before? It's a pretty ham-handed way of asking for that information. This is what you're going to get from me. Objection, that question is improper. It's requesting information respecting other bad acts or propensity to sue. That's the other side of it. It's not reasonably designed to lead to admissible evidence. Which is still the standard, again, over and over under Rule 221 of the Uniform Rules, which is not the CPLR. Okay, the Uniform Rules is something separate. It's a separate body of regulations. I'm directing my client to not answer that question, you know what? I'm marking it for a ruling too. So I got a whole bunch of things here. I got a lot of problems with this deposition over here today. And then, okay, it's a negligence suit or a wage and hour suit and defense. You're on the defense side, and they're asking about personal assets. Well, it would seem like that might be relevant, wouldn't it? If you're asking about what somebody owns and where their bank accounts are, just in case you win. Nah, wrong. Objection. That question calls for information that would be the subject of what's called, ready for this? Supplemental discovery. All right. See, we're in discovery right now. Okay, we're exchanging documents. We're asking questions at a deposition. This is discovery. We're getting documents, to prove or defend the case, right? Prove our positions. Supplemental discoveries is what happens after a case is over and after you get a judgment. So Article 31 and Federal Rule of Civil Procedure 30, they cover discovery during the actual litigation up to the trial. After the trial's over and after you have a judgment, 31 and 30, CPLR and the Federal Rules of Civil Procedure, no longer apply. We're not in pre-trial discovery anymore. Now we're in post-trial, post-judgment. All right, so we're in a whole different area, a whole different bunch of rules. And that's when you get to ask the questions about assets and where your bank accounts are and what transactions have you made. That's supplemental discovery. But in my pre-trial deposition, you're not getting that information. It's improper. That is the subject of supplemental discovery, and counsel, you know it. All right, so that's not a nice thing to do. So they're not getting that information on personal assets. Okay, so these are situations that it's a very dangerous area, and you really have to be practicing for a little bit to understand that you have this power that, and we warn you, you are warned constantly in law school and in your ethics classes that you have no authority to direct your client to not answer a question. But sometimes you have to, and sometimes you got to take a chance, and, you could always change your mind. For example, you get the personal assets question, just as an example, and you're not sure, you direct your client not to answer, whatever, okay? At some point you say, listen, I just need a quick break or whatever it is. And you could do one of two things. Number one, you could do your own research on your phone as you're there, or your laptop or whatever, or you can call your office and say, look, this is the situation I'm in. What do you recommend that I do? And the answer is going to be different depending on, through your research or through calling, for backup counsel. It's going to depend on what kind of case that you're actually working on. So that's what you're going to do in these situations. But there are times, and I hate to say it, and I'm sure that there's going to be debate and there's going to be some criticism on people that watch this. There are times when you must direct your client to not answer the question, or to just stop and say, look, I'm going to move for a protective order. Before I even direct my client to not answer the question on the record, I'm moving for a protective order. We'll get a ruling from the judge, or we can call the judge now and ask whether that this is an appropriate area for you to explore during the course of your deposition. Okay, so that's what can be done at this point. Let me just tell you something about the objections. You have to interpose at least one objection during your first deposition, because you're not a true lawyer until you get to say objection. So learn your Marvel acts, know your objections, and make your objection, but direct your client that they can answer over the objection. Okay, so let's let me just talk about one of our pet peeves, because we're going to get back to the objection sheet in a second, and that is that Stacy was having a problem with too during her deposition trials and tribulations. Was the do you know question. The do you know. The only time you should ever have that phrase in your question, do you know, is if it's preceded by how do you know. Okay, that's okay You can ask, how do you know? Because you're going to get more information about that. But the do you know, I think we have demonstrated in that frog that we opened up and looked at, that's not a good. Try to lose that as much as you can. I'm gonna keep reminding you about that. However long our seminar goes, how many hours. So here's the question. Do you know if it was raining? All right, Stacy, you don't have to object. I know, I got you. Stacy objects to the form, but she says you can answer over my objection. But counsel now really wants to know, do you know if it's raining? It says, what's the basis of your objection, counselor? And the answer will be, well, the form is improper, okay? The response requires a yes or no answer. However, the reader, and now I'm just amplifying, I'm not arguing. However, the reader of the transcript, you say, oh, the reader of the transcript is not going to know if the answer that they give, which is yes or no, right, corresponds to whether the witness had knowledge as to whether they know if it was raining, or if they know, in fact, it was raining. So you have a lot of problems here. So you say, I'm not trying to object. I'm not trying to engage in colloquy here, but, if you like the question, as phrased, keep it, but I'm going to object to the form. They can answer over the objection, just don't complain to my client, after they say yes or no. You can't say, yes, it was raining, or yes, it was raining. Okay, because that's logically what's going to happen next. Okay, now maybe we're engaging a little colloquy here, and just say, look, next question. Then you might try and doing the metrics on this particular question. You might try what were the weather conditions like at the time of the accident, but that's just a suggestion. You can do whatever you want. All right, carrots, cooking carrots. Let's go to the, and I told you I was going to remind you guys in the beginning about the objections to the answer. And I only have one there on your objection sheet. And these sheets may grow too, so don't hold me to this, who knows. But it's when you ask, for example, what were the weather conditions like at the time of the accident? And they go on to a whole story about how the skidding was, it was raining, and that's why it caused everybody to skid, and that's why I couldn't control it. And that is not responsive to your question. So you say objection, I move to strike. The answer is not responsive to the question. Let them finish, doesn't matter. Any portions of their entire answer are going to be stricken, with the exception of the yes or whether it was raining, or I think the question was, what were the weather conditions like? It was raining. Anything after that is going to be stricken. All right. And because you have you probably said objection, move to strike. Boom. That's good. Good enough. Better, objection, I move to strike. The answer is not responsive to the question. That's all. Both of them, you get the same result. Okay. I promise you that. It's just better. And when you're at trial, don't just say object, move to strike. If it's becoming repetitive and you have to use it a lot, then do it. But make sure that the record is clear that, objection, I move to strike. The answer is not responsive, responsive to my question, Your Honor. I just asked that everything after it was raining be stricken. And then they'll make a ruling on it, and then you would ask the judge you say, you want me to have it, may the jury be instructed on that. And then the judge will tell them, the jury, you are directed to ignore everything after it was raining. It's not evidence and it's not part of the record. So that's how that works. Now to objection to counsel's behavior. And this stuff can happen right out of the gates too, if your opposing counsel thinks that they're a combatant and they think that this is, that litigation is combat. The first objection, you notice I have objection, there's no reason to be, and then I have one is raising your voice. The cold record is not going to indicate that anybody is raising their voice. You're going to be reading and assuming that these are lawyers that are speaking, and that that everything is collegial and everybody's being rational. All right, so if they're raising their voice, you say, objection, counsel, there's no reason for you to be raising your voice. The witness has been cooperative, been answering all of your questions. There's no reason for you to be agitated. All right, so there you have that. Another one, sometimes in a hyperbolic display of theatrics, opposing counsel will stand up because they're indignant at the response that they receive. Stop that right away. You say, objection, counsel, there's no reason for you to be standing up. Please sit down and conduct yourself in the manner that you would a trial. Okay? So, I mean, yeah, I know that you do stand up at points, but not the way that counsel did it in the deposition itself. And by the way, in federal court, you're very often you're tethered to the podium. So just so you guys know, and there are some courts in the commercial part, like Judge Ramos used to be that way, where they didn't want any theatrics and walking back and forth and getting into the juror's space. They wanted you at the podium, and which is good practice now in the time of COVID anyway. Then you have counsel that likes to roll their eyes or, huff and puff, and you have to talk that into the record. And that's what I recommend you do. Objection, counsel, you're engaging in improper gesturing. I don't know why you're doing that to the witness, unless you're trying to upset them on purpose. They'll stop, okay? First of all, they'll deny it, and then they'll stop. And then you have one where counsel decides that it's appropriate for them to interrupt the witness in the middle of their question. And you just object to that. You say, objection, there's no reason, counsel, there's no reason for you to be interrupting the witness, and it's improper, okay? So then to the next class of objections, we have the you are not permitted objections. And we talked about that a little bit last week, and the objection was, counsel, objection, you're not permitted to coach the witness, all right? And that's when they're, pointing to things and tapping on the paper, it's like, oh, yeah, like, don't forget that, they're saying to you, they're coaching, all right? They're not allowed to do that, all right? And you put that on the record that they're doing, they will stop. And we say, objection, you're not permitted to give verbal nudges. And we talked about that, right? When they add, you ask the question and they add to your question, if you're not allowed to do that. Objection, counsel, that is a verbal nudge, and that you're not permitted to do that. And mark this for the court's attention, right? So then this way, whenever you're going to your index, which is at the back of the transcript, and you're making your motion, just like you remember, attention, attention, attention. And all those you'll be able to cite to the record. And if they ask you why, you're saying, what do you mean by marking for the attention? You say, well, that's when I make my motion, I don't have to go crazy reading this ridiculous transcript all over again, because quite frankly, it would give me a nervous breakdown. So this way I just have it in the index, and every time that I have to mark the record for the court's attention because of your ridiculous behavior, I don't have to, I can read as little as possible. I mean, you don't have to be that, obnoxious either. I'm just, trying to be funny to get the point across to you all, okay? Because I prefer to be nice to opposing counsel. And it's been my experience that most of the attorneys that I have dealt with have been nice. And the ones who were nasty with me, once they knew that they were not going to get away with anything, they became nice too, because I really believe deep down inside, attorneys are every one of them are all good people. Anyway, moving on. Here's one where you ask the question where the attorney decides that the attorney decides that you do not know how to put a question together. So I'm going to rephrase your question. It's a race. I'm going to ask it for you so you can get all this great information against my client. Thank you very much. Objection, you are not permitted to rephrase my question. Because remember what we said, state and federal, the conduct of a deposition is the same exact way as it's done at a trial. Not exactly, but it's the same way as a trial. And opposing counsel sitting at the other table is not allowed to rephrase my question that I have asked the witness in front of an Article III judge. They're not allowed to do that. And they wouldn't dream of it. So then why are you doing it here? Come on. You don't have to be that way. And then, if they want to, if they want to ask the question, they are able to do that at the end of your deposition. So they can't, and that's the last one I have here. They want to ask, they're not rephrasing your question, but they're asking their own question, which may be relevant to you, may be important to you, but you don't allow counsel to ask a question. And that goes for the, for your whoever's on the same side of the V. Don't let other counsel ask the questions for you. And if you're defending and on the other side of the table, the attorneys start asking their own questions out of order, you have to object to that and stop that immediately. Everybody gets their turn, all right? It's not a deposition by committee, all right? And if they'll be able to, they'll have their opportunity to ask their questions individually. Certainly during a break, they can suggest to you like, hey, can you get into this area, which I have done actually with co-counsel on, excuse me, with for example, co-defendants, and they were first on the caption as the defendant, so they got to ask the questions first. Then I would say to them, so I wouldn't have to go and wait until the end. Hey, do you mind asking about this area? And every time I've done this, I was like, oh yeah, I'm going to get to that. I'll do that. I'll take care of that. And if they don't want to, say, okay, I'll take care of it myself. Never had to do that, but I was prepared to say, okay, then no problem. I'll take care of it during my own examination. And that's your objection worksheet. And I know it's a lot of stuff there. And we have about 8 minutes left. And first of all, let me ask, are there any questions on what we've covered so far today?
I got two, but I could save them.
Give me the second one first.
Why the second one first? I will. But...
Just kidding, Greg.
The more responsive one to this particular issue that isn't hyper-specific. Going back, how do you address responsive answers to improper questions for which you've already objected? However, your adversary is now moving to strike the non-responsive portion. So for example, like you said, tell me about college. Objection, that's a narrative. Answer, I was planning on being a physical therapist, but your client broke my neck, so I had to change majors. Other counsel moved to strike as being non-responsive. Now it's perfectly responsive for your purposes, but you've already objected. Do you now withdraw your objection?
You know what, you can withdraw your objection, which is fine. No one can prevent you from withdrawing your objection, or you could just ask the question again in a different phrase and more specific. Just recast the question so that you get the specific information that you want. But you can absolutely withdraw an objection. Absolutely. So that's a really good question, Brett. What's the next one?
The next one's kind of specific. It was about your suspension question.
Go ahead.
Well, I've encountered the suspension issue a few times, and it causes problems. So I'm just curious on your reaction. Assume proper foundation on all the questions just for purposes of brevity. So do you have a New York State driver's license? Yes. Is it valid? Yes. When did you get it? 1990. Between 1990 and today, has the status of your New York State driver's license been anything other than valid?
Objection. That's just that question is not even a wolf in sheep's clothing. That question is a wolf coming as a wolf. It's just the same question, man. So I would object to it because it would yield the same thing. It's clever, right? But I would still object to it, and it would be, I believe it would be objectionable.
Thank you.
You're welcome. Anybody else? Awesome.
Joe, sorry, if you have two attorneys on one side, so one attorney is the main questioner and he has an associate with him, can the associate also ask questions and jump in?
It's an excellent question, and it would seem that that would be a great teaching tool to be able to do that. But let's think about what the federal rules say and what the CPLR says. The deposition is to be conducted in the same manner as a trial. every trial that I have been in, the judge requires one attorney asking questions, and that same attorney must be the only one that defends on cross-examination, no matter how many attorneys you have sitting next to you. So so the answer is the other attorney must keep their mouth shut, and they're there to watch. But if it's for purposes of training, I would contact my opposing counsel the day before, inform them that I have either a student lawyer or a brand new lawyer that is coming in training, and would it be okay if they asked 5 questions, which I have done, and they were happy to participate in that. But the answer to your question is no. It's not deposition by committee, just like it's not a trial by committee. One attorney for each witness, and that goes for the questioning. And then that same attorney sits down after they question, and during cross-examination by the other side, only that attorney can object. Now, can co-counsel whisper in their ear and say, I think you should object to that? Absolutely, yes, that's fine. But only that attorney may appear on the record at trial.
Thanks, Joe.
Is that it? Oh, you're welcome. Anybody else? All right, so now let's turn to Israel, and I'd like him to share, we only have a few minutes, but I'd like him to share as much as possible his experience, starting from the beginning of his deposition in the Redder case. Israel?
Sure. So I'll say that I felt fully prepared for everything and nothing caught me off guard. So I was ready for anything that came my way. So that was really important. But I'll say that the deposition did not get off on a good footing whatsoever. And the attorney was much more obstructive than I anticipated. First off, the depo was called for 1 o'clock and the attorney didn't show up until about 10 to 2 without any, contact or warning or anything. And then the witness advised me at 2 o'clock, oh, by the way, I have to go at 4:15, which was the first time I heard of that either. So before I started the depo, I put on the record that counsel was about an hour late to the deposition. The witness just advised me he has to leave in 2 hours. So we reserve the right to recall him. And before I can get through saying that, opposing counsel cuts me off. And he says, Israel, I know where you're going with this. Let's just get to the point of everything. And I'm like, counsel, it's not appropriate to cut me off. I'm permitted to make a statement and you should not be speaking on my record. And then I jumped into the questions, but every other question was objection, objection, objection. And I asked him, what's the basis for your objection? He says, well, I don't have to tell you that. And I say, well, yes, well, awesome. Yes, you do. So I have the opportunity to correct my question if there's a problem with it. And then he looks at me with like a blank stare and he says, can you repeat the question? Like he doesn't even know what he's objecting to. So I had the court reporter repeat the question back. And then he just made up something that wasn't even relevant. But it was just every other question. And I questioned whether or not I should just call the depo for the day because it's like pulling teeth there. I'm fighting with the witness and opposing counsel. And, it's throwing me off my rhythm. It's giving the witness time to think before he speaks. And I kept admonishing opposing counsel. And I said, you know better than this. Speaking objections are not permitted. If you have objection to form, state your objection. He many times instructed the witness not to answer based on relevance, which is completely inappropriate. And I, of course, marked it for a ruling and moved on. But at one point, the witness was starting to answer something and he stopped the witness because I asked at one point, what were the addresses for all the locations? And the witness is like, oh, well, I have a business card right here. Let me go get it and I'll read it off to you. And his attorney stops him and says, no, you don't have to do that. And I'm like, counsel, the witness is speaking, don't interrupt him. So it was like pulling teeth, but we got through it at the end. And I think I got a lot of useful information out of the witness.
Well done, Israel. I'm really proud of you. That sounds like really, really good. I promise you, you will never have a deposition as hard as this one. Not in this way, anyway. The rest of them are going to be simple compared to this. Sometimes we run into trouble when we're dealing with interpreters because sometimes our interpreter is really not that good, and it can be really, really problematic when and you know that the record is going downhill. and you're not getting good information. But I'm glad that you handled them. You handled them well. You marked you marked his inappropriate behavior for rulings. You protected your record, and it sounds to me like you performed appropriate metrics analysis on each of your questions and answers and objections. So well done. Thank you for sharing that with us. Remember, guys, for your and I'm not, this has nothing to do with what Israel did, but for your depositions, who, what, when, where, why, how, these are all appropriate ways to ask questions, open-ended as much as possible. Now, if for basic information, for pedigree information, it's okay to use leading questions, or if they're you know, if they seem confused or nervous, and it's not information that's dealing with liability or dealing with culpability, you know, I guess, which is the same, but that's when you want to stay away from using the leading questions. But if it's to move the record along, it's fine to do. Even, you know, even if if there's an objection to the form, then you can just rephrase it and you'll be good to go. So I see we're running out of time, and we're actually 1 minute over. I hope this one was helpful. We're starting to get everything and pulling it all together. And we've seen one of our attorneys accomplish their first real deposition under this kind of training. And you know, I hope we keep studying, keep improving. Go over your objection sheets, keep it close to you, hang it up next to you so you have it and you can look at it all the time, because you're litigators and you're going to need this. And you can practice these things. You can practice asking appropriate questions in real life, in your writing. Pay attention to what you're writing, pay attention to what you're saying, and make your questions and put them into forms that would be appropriate. I mean, you don't want to add language that makes you sound like a ridiculous lawyer, okay? But you do want to ask appropriate questions. The shorter your questions, the better it is for you, the better the transcript you're going to have. Stay away from the fighting. Israel did. You know, you have the wrong attorney going up against a guy like that. He wins because there's going to be a fight and the deposition is going to bust. Israel is put into a situation where the deposition very easily could have busted, but he didn't. He stayed there. He got the information that he needed, and he saved his client some money, and he got us a good case. And we're back in the kitchen, and we're cooking carrots again. So if there are no further questions, I'll see you next week, and thanks for participating.